Hi there, I'm Immigration Attorney Heather Poole. Did an immigration judge deport you from the U.S., or did a CBP officer issue an expedited removal order against you at the border when you tried to enter the U.S.? Do you now have a loved one or employer willing to sponsor you for a green card? Let's help get you back. Another example of someone who may need the I-212 is someone who tries to come into the United States on their B-2 visitor visa, but CBP finds out that they have lied about a prior overstay when applying for their new B-2 visa at the consulate. CBP issues an expedited removal order and finds the person inadmissible under Section 212 for committing misrepresentation, a ground of inadmissibility that is a lifetime bar unless waived. That person would both have to apply for an I-212 application to come back because they now have a 5-year expedited removal order issued by CBP, but they would also need an I-601 to apply for a misrepresentation waiver to waive that past fraud. The I-601 inadmissibility waiver is different, though, than the I-212 application. They have different standards for what you must prove. Unlike the I-601 that requires that you show extreme hardship to a U.S. citizen or lawful permanent resident spouse or parent in most cases, the I-212 doesn't require that you have a particular family member. This helps those who may have to waive a removal order who have an employment-based green card waiting for them, but have no other ground of inadmissibility that requires a qualifying relative. USCIS will look at various positive and negative factors in deciding whether the immigrant deserves to be granted the I-212 application, and thus deserves to come back to the U.S. prior to the expiration of their removal order. The positive factors that USCIS will consider are: 1, are you a good person? How long ago were you deported? Were you deported 5 years ago, 6 months ago? The need for your services in the United States. This is often very similar or the same as an extreme hardship argument in the 601 context. Basically, is someone else in the United States, do they depend on you? Do they need you back right away? Another factor they're going to look at, whether or not you had a reasonable belief or knowledge that you didn't know you were actually deported. That one usually doesn't work. How long were you in the United States? They're going to look at that. They were also going to look at why were you deported? What were the reasons? What was the severity of your past immigration violations? Was there a serious crime involved? They're going to look at, have you been reformed and rehabilitated? Are you working to be a better person? Are you getting educated? Are you helping other people? What are your family ties and responsibilities to family in the United States? And lastly, what is the hardship to you and to others if you can't return to the United States? But all of this is really not going to make a difference if you don't have a way to actually come back. The I-212 doesn't give you a green card. It just waives that deportation order so you can take advantage of a green card application actually filed for you. So you're going to have an approved immigrant visa petition waiting for you. They're going to look for that. If you don't have that, they're not going to issue you an I-212 application. USCIS also looks at negative factors in deciding whether to give you this positive grant of discretion, the I-212 approval. They're going to look at, are you a constant rule breaker? They're going to review your significant immigration violations. How often did you keep breaking the immigration laws? And really, is there any point in granting you the I-212 if you also have a ground of inadmissibility that has no waiver available to it? So for instance, if you claim to be a U.S. citizen, to get a job or on immigration paperwork or to vote, there's no waiver for that. So there's no point in granting you the I-212 if you can't even get an I-601 waiver, so you're not going to be able to come back anyways. The I-212 application is usually filed from outside of the U.S. unless you are also applying for a provisional waiver. Where the application is filed within the U.S. will depend on how you were deported and by what federal agency. Consult with a competent immigration attorney about your case before filing anything. You don't necessarily have to wait the full or 10 or 5 years if you have an expedited removal order outside of the U.S. Just don't try to legally re-enter after a removal order to wait out the time your case is pending. This will stop your chances dead in their tracks. You won't be able to come back. Don't try to re-enter, period, without an approved I-212 if you have a removal order and after issued your immigrant visa by the consulate. You've waited this long already. Don't screw it up in the final mile. This is obviously some complicated stuff. You need to talk? Visit our website, humanrightsattorney.com, to book your appointment to discuss your case with me or give us a call today. If you would like to hear more about this subject, please comment below and give us a like. Thanks, and good luck out there.